He says, what is the IBC going to do in the world of getting justice for people who are in darkness about what is their future in resolving the disputes? And he is a very forcefully written piece in this. I thought I should read the rest of the contribution before I read his article, because I can become a little biased in looking at the possibility of settlements or the lack of it in the insolvency field. But then as I read through some of the articles relating to the Commercial Courts Act or mandatory versus directory, and all a wonderful piece of thoughts and ideas, which egg us on to go beyond the pedantry ways of looking at mediation and things like that. So as we try to enter into this debate, before I come to Sriram Panchu's very incisive piece and how it gives us a very important perspective on how you look at mediation and all that. So I was trying to pick up some ideas today. You cannot come on an important book launch like this without having prepared yourself at least minimally, if not fully. So I was looking at described litigation as a machine which you go into as a pig and come out as a sausage. I think it's an important, very important, significant statement. So if you want our adversarial legalism, because I think over a period of time across continents, the ability and the cultural inclination of people to settle disputes without getting into formal dispute resolution processes was lost over a period of time. The civilizational value was lost. So we get into a adversarial legalism. One of the authors who wrote a book somewhere in 1992, I think Leonard Rosenthal, who talked about the values of how adversarial legalism had produced different outcomes in France and England. In the context of France, it went into a different direction. In England, it flourished. So adversarial legalism, even in different parts of Europe, had seen different outcomes. So the cultures or the nuances of adversarial legalism in different countries that produce different outcomes. But what do we learn from an adversarial legalism? How long are you going to be tied up with? Important for us not merely look at what called the pedestrian ways of whether making mediation and mandatory or making it directory and so on and so forth are one level of looking at mediation and the values of mediation. We need to get into a different higher levels of looking at that. So how do we therefore, I thought this book is an important initiator to go beyond those what we call the legalistic pedestrian ways of looking at mediation and its prospective contributions. So I was also looking into the book on two important contributions. I thought I was refer to them because another article in the same book talks about how it says those who criticize settlements suffer from what I have called in other contexts litigation. I think it's a very important way of looking at it, because now we become so involved in the adversarial legalism that we become romantics with litigation. So whenever there is a possibility or a scope or a debate which is initiated or assured, to look at other ways, the theatre of IBC, two important theatres where this book I'm sure. So I think I must congratulate both Justice Sikri and our Commander Batra on the very important contribution. But I have a few more reflections before I conclude. Now, we talk of party autonomy in arbitration, right? It's sacred. But we don't talk of party autonomy in mediation. Why not? Because after all, you party autonomy towards the very persuasion to become autonomous and be participating in settling your disputes. What is its value as compared to a party autonomy in arbitration? Party autonomy in arbitration is enforceable. So we still have not reached a stage where the importance and the sacredness of having contracts drawn, where mediation will have a certain fundamental value. And then therefore, then we did not get into the question whether a statute should provide something should be mandatory or directory. So if parties are persuaded to move into an entirely different what called perspective and approach to dispute resolution. Somewhere I find even the dispute resolution word has been borrowed from an adversarial legalism. Probably we need to look at some more better or more persuasive expressions and things like that. So if that is how it is, why can't we go into a stage where universities, law schools, and courts also began to talk of the importance of contractual, phrases where mediation will become an integral part of mediation settlements and all that. And if you, Mr. Khan talked about the rate of decrease in resolutions in the IBC field. It can be traced to many factors. Like you use from DRT to SURFACE, then we have had the SICA Act, and then we into IBC. So if you trace the evolution of those efforts, then every effort has been, I think, confronted with the internal conflicts which the law did not perceive when the law was enacted. So IBC will probably face that in sooner or later. But that's not a criticism in a negative way. Because many of these, that's why if you talk about an adversarial system and to try to build all procedures around them, I think the procedures begin to bother us. The procedures begin to drag us. They become dragging factors. Whatever one may say about the importance, or for instance, the Commercial Codes Act, there have been several amendments. So how far your procedures will become a confronting element. So I think, therefore, as long as we stick on to an adversarial legalism in our dispute understanding and dispute resolution, we'll be tied up with these issues. So it's important that Sikri has opened our eyes to looking at dimensions which would not normally perceive. They are built into this book, but I think it's not a book for a one-time attention. It's a book which calls you to keep reading again and again, not only for your own reflection, but for you to share those reflections with the legal community in order that So sometime back we thought we were talking about ad hoc versus institutional arbitration. And one idea was to bring in a bar, an arbitration bar. We could probably try to improve or probably fasten an important element in institutionalizing arbitration. So in the course of time, I also thought, I've been speaking to many people in the bar, that we'll have a national mediation bar. And this mediation bar will probably be part of looking at, and after all, when the initial days of legal aid, people wanting to do legal aid services, were not very favored lawyers, right? You belong to a slightly lesser level of your legal practice. But today it's very different. And I think it's important for us to say that as long as and as far as people who enable people to settle disputes will stand in the higher echelons of the bar, I think that will be a great index of the service to the nation. Therefore, I would welcome all possible thoughts and ideas on how to have a national mediation bar, and we try to spread as far as possible and as wide as possible and as intensely as possible. So I think, thank you for inviting me here today. I thought I'll share these humble ideas with you. I think the book will travel far and wide, and I'm sure if anywhere you need any one of us as party, your journey partners, we are there to help you with. Thank you so much.
Thank you, Mr. Venkatramani, for that insightful address. Now I would like to request Justice Manmohan to please address the audience.
Respected Justice Suryakant, Mr. R. Venkatramani, Mr. Amitabh Kant, Justice Sikri, Mr. Sumant Batra, the members of the EBC family, distinguished ladies and gentlemen. See, the title of the book I find is very, very interesting. It says, Mediation in Insolvency, a Game Changer in Viksit Bharat. According to me, a Viksit Bharat means a nation that is developed, that is fair, and that is economically prosperous. How do you do that? You do that by ensuring that private enterprise in the form of companies, in the form of industries, flourishes. People who set up industries, who set up big companies, they always take a chance. No one is sure that the business will grow and they'll be successful. So there is always a downside that the business may not succeed, the venture may not succeed. If that is so, then we have to have a proper mechanism to deal with the financial distress that is generated by the failure of that venture. In any growing economy, you cannot have too many stressed loans, too many stressed assets. You have to ensure an expeditious resolution of the dispute, and the dispute must be resolved to the satisfaction of all the stakeholders. When I was a lawyer, I was primarily practicing on the corporate side, and I can tell you that the interest of the stakeholders can be very, very different. The employees' interest in settlement may be entirely different from what the investor's interest may be, or the shareholder's interest may be. There would be creditors who would be looking at it from a totally different prism. There would also be third-party contracts which would have been executed midway, who would be looking at the scheme of rehabilitation, amalgamation from a totally different perspective. How do you bring these competing interests on the table and resolve it expeditiously? Taking a very legalistic approach in the court process, especially in a system which is already overburdened, we see that in and day out. We all know even our NCLT are overburdened. A large number of writ petitions are being filed seeking early hearing in the matters which are pending. So the system, the judicial system, has a limited capacity. But in a country which is growing and growing at a remarkably fast pace, I think we'll need to look for new tools to resolve disputes and to resolve them at a fast pace. I think mediation is one of the tools that we need to try. I expect that it could be a game changer when it comes to resolving disputes in insolvency. There are some inherent advantages, as we know, of the mediation process. One is it is flexible. It is not to be done in a straitjacket manner. When law is administered, it is normally done in a very straitjacket manner. The procedure will have to be followed, notices will have to be issued, everyone will have to be given a written notice, you will have to see his reply, then decide. And it may not be possible in a legalistic manner to balance so many interests that we have to deal with. In insolvency, that flexibility that you have of accommodation that can be done, I think you can achieve that result nowhere else. It will also ensure that it is cost effective. And the most important aspect that I see in this tool is there is confidentiality. People in the business world are very, very touchy about matters or the word spreading around that their companies are not doing well. So therefore, I think it's one of the characteristics of the mediation process is confidentiality, and that I think is of great significance. Also, the inherent concept in mediation is that it is fostering a spirit of cooperation and collaboration, and not a spirit which gets really promoted in the adversarial system is who gets priority. So in this adversarial system, the question is, who will prevail? That attitude is entirely different, or the approach is entirely different in the insolvency proceedings, in the mediation proceedings. Now, it is also, I think, a very efficient and a very human way of dealing with this complex problem. Because of the accommodation that it offers, because you sit across the table, the mediator will guide you on what is to be done, what is the best way forward. And let me tell you, I am not speaking off the cuff. I have known at least of 2 or 3 incidents where Justice Sikri, acting as a mediator, has resolved the insolvency proceedings and the notices have been withdrawn in 1 or 2 cases. I think one of them was Intech Capital, if I correct. Yes, that is in 2018 or so. Yeah. So, great results are possible, and it has happened. It's just that this moment has to take off, and I am sure with the backlog that we have, with the thirst for success, everyone wants to succeed today. No one has the time to wait. No one wants, as previously said, that the litigation should be passed on to the next generation. They want an immediate resolution of the dispute, and they want that the company should have a second chance of life. I think we as Indians have to get used to this, that even if a business venture fails, it must be given a second chance. Maybe it succeeds the second time if it failed the first time. So I think this is a great tool, a great concept which needs to be promoted. I am very happy that Justice Sikri and Sumant Batra have taken on the challenge to deal with a topic which is just emerging. In fact, this jurisdiction is what I would describe as a sunrise jurisdiction, because I see a lot of potential, not only in insolvency, but also of use of mediation in insolvency. Therefore, it's a credible work on the interface between mediation and insolvency. I congratulate you. I think it is path-breaking. I don't think there are many books on this aspect. So I congratulate both the authors for the path-breaking step that they have taken. And I believe this is time for transformation, and this is a transformative approach which has been suggested by the authors. A lot of experts have contributed. Number of chapters have been written by experts. And I'm sure it will be a great tool, a great base book, if I were to call it, a referral book for scholars to develop and to, improve their skills with regard to mediation in insolvency. Thank you very much for inviting me and for making me a part of this book launch, sir. Thank you very much.
Thank you, Justice Manmohan, for the enlightening address. It is now time to invite our chief guest for the evening, Justice Suryakant, to please come and address the august gathering.
Slightly deviating from the format of protocol, I will first address Dr. Justice A.K. Sikri, former Judge of the Supreme Court, and my evergreen Chief Justice, Justice Manmohan, Chief Justice Delhi High Court, judges from Delhi High Court, Mr. R. Venkatramani, Attorney General for India, Mr. Amitabh Kant, G20 Sherpa, Mr. Sumant Batra, President of the Insolvency Law Academy, Mr. Sumit Malik, President and other office bearers of the Delhi High Court Bar Association, senior advocates, distinguished mediators, members of the legal fraternity, ladies and gentlemen. It's undoubtedly a privilege and honor for me to be here with you on the launching of this book, as rightly said, a game changer. I'm thankful to Justice Sikri and Mr. Sumant Batra for giving me this opportunity to be with you on the launching of this book. Justice Sikri in his speech hinted how the courts are overburdened, and right from the district courts to the Supreme Court, we keep on talking of dependency, the areas, the timeline within which we'll be able to address those pending matters. Mr. Amitabh Kant, in a very eloquent speech, he highlighted the importance of the IBC as a legislative mechanism introduced for the fast and speedy and timeline disposal of the commercial disputes. But then he also flagged the issue of penancy before the NCLTs or NCLAT, and how the timeline prescribed in the statute is not being adhered to, maybe on account of the overburdened institutes. And it is in this backdrop that the importance of mediation in the field of, or in pursuant to the, in a branch of litigation, commercial litigation, I would say, the insolvency, the importance of mediation arises. When we talk of insolvency, basically it's a stage of a commercial dispute. When you are unable to resolve the dispute amicably through your coordination, your negotiations, or maybe through other different platforms, then eventually the dispute will end up before one or the other adjudicatory forum. And insolvency, of course, is that form or that stage of the dispute where the parties in a way are in a mood to fight. And still then we think of introducing the insolvency, the mediation as a tool of resolving that dispute. So why mediation can be a successful tool even in the matter of resolving the insolvency disputes? I find 3-4 reasons. 1, the creditor is very keen that he must get back the amount which he has invested or which was borrowed from him or which he lent that amount. The debtor is very keen to rebuild the business. The shareholders are, of course, again very keen to safeguard their own stakes because they have also made investments in the business. The operational creditor are also under a lot of fear that in case their supplies, the long-term business relationship is come to an end, ultimately their industrial unit or whatever services they are providing into the industry, they will also be in danger. And that fear in all the stakeholders is the real platform, the ground on the which will definitely invite the parties towards mediation. But there is another very important investor to whom I call the invisible investor in this entire scheme of commercial dispute. And that invisible investor is the state itself. If the industrial units will come to closure, if merely because through the insolvency processes the business can be auctioned, can be dismantled, and ultimately whatever scrap is left that can be sold, who is the last end loser? The last end loser is the economy of the country. Mr. Amitabh Kant talked about that how we will be able to achieve our target of Viksit Bharat in 2047, and for that how much economic development the nation is required to have. That can only be done if we are able to save our industry, our businesses, our services. And therefore the importance of insolvency comes, in the matter of insolvency, the importance of mediation comes into. Like any other commercial dispute, we should be with free mind ready that mediation can be an effective tool even for resolving the disputes which have reached the stage of insolvency proceedings before the tribunals or before the appellate tribunal. Having said that, the advantage of mediation, as the learned Attorney General pointed out, the earlier speakers also pointed out, let us have the mediation completely liberated from any kind of format procedure. It must always be kept completely flexible procedure, where you never know on what point the parties may come to a settlement. And therefore, the mediation itself should be a very speculative procedure, that even if you failed at one stage, the effort should continue, you may succeed at the second point of time. So the mediation will have always that advantage, that it's not failure at one place or at one stage of the dispute is not the closure of the door. There is always a room available, there is always a scope, there is always a possibility of the parties again entering into a kind of settlement. And this has happened, and every day it happened. Even at the level of the Supreme Court, we are seeing that the parties who have successfully failed, I would say, repeatedly failed, they eventually come and realize that what is the importance of settlement. All of you know the importance of settlement is what? We have always said that compromise is the soul of justice, and compromise is the mediation. Therefore, mediation always has a part of our social value, our social fabric, our moral values, a part of our civic society, a part of the rules which always regulate the society, whether in the past through panchayat system or through any other regime, till we came to the codified laws in 1947 onwards, when through various statutory provisions we have introduced mediation as a statutory or as a formal mode of settlement of the disputes. We have so many global examples where the insolvency proceedings have been effectively settled through mediation. I recollect the Lehman Brothers, I think, is one of the most celebrated instance which is quoted in the US, where I think 77 areas of disputes were identified, out of which 73 were amicably resolved only through mediation. I think MF, there was one more dispute which was between UK and the US parties. That was also, and the stage was also, there also it was insolvency stage, the MF Global Holdings. That was also a dispute of insolvency stage, where the parties amicably through the mediation were able to resolve the dispute. Justice Sikri must be knowing better than us that in Singapore also it has been successful. So why should we lag behind? And in a country where the litigation has been increasing with the passage of time, people becoming more and more aware of their rights, and most importantly, when the country is inviting direct investments, the investors are coming, our economy is robust and stable, and where there is a lot of attraction for the foreign investors, I think in this emerging scenario, the mediation should be kept as the first-hand tool of resolving the disputes in this emerging field of the commercial disputes, where, as I said, insolvency is only one of the stages where the dispute, as it seems to be, that has gone out of hands, and the party leads to approach the forum for resolution of their disputes. The book, I must say, is an excellent compilation of the best of the brains who have worked in the field of mediation. All the authors who have contributed the articles, I think, have their own expertise and experience in life. Justice Sikri is the leader among them. I can share a small experience that in my high court where I have been practicing, and in the days when we were in practice, mediation was not a very popular kind of alternative mechanism at that time. I was incidentally a very firebrand kind of aggressive lawyer, so never thought of mediation as that we will ever be involved in that. I became Advocate General, I was 37, then became judge, I was less than 42. So mediation was not the cup of tea, as I would say, at that time, and we never thought of that it can be an effective tool. But after my elevation as a High Court judge, and in 2005 onwards, and when we started hearing about that mediation can also be something which can be explored for the purpose of dispute resolution. And Mr. J.P. Singh would recollect that when I took over the Judicial Academy, and when Mrs. Ramchandran and Mr. J.P. Singh, they used to come from Delhi, and we used to train our judicial officers with the idea and hope that maybe that some of the matters they will be able to resolve through mediation. So that training part, then at that stage we started really taking interest that yes, mediation can be something which can be through a win-win situation will be able to resolve the dispute. And I must say that with the passage of time, I did realize that yes, mediation is something that's a very effective tool. It's cost effectivity, time effectivity, relationship effectivity. When I said in the context of insolvency, see please people who have set up the industry, they have a lot of attachment also with the industry. There is an emotional bondage with the business you start, and the people want to save that. So when we talk of emotional bondage, we talk of mediation. The commercial disputes, this book is a real guide. It's a very, very effective tool. As learned Attorney General said, this is not a book that you will read and keep in your almirah. This is something, a toolkit which you need to carry with you whenever you are involved in the mediation proceedings. My heartiest congratulations to both the authors and the authors of the 22 or 26 articles contained in the book. Each one of them have really done a commendable job, and they deserve the applaud and heartiest congratulations to each one of them. Thank you very much, Justice Sikri and Mr. Sumant Batra, that you invited me and I could share my views with you. Thank you very much.
Thank you, Justice Suryakant. It is always a delight to listen to your insights. Time has flown by and we find ourselves at the close of this remarkable evening. But before we conclude, it is essential to acknowledge the contributions that made this gathering possible. I would now like to invite my friend and colleague Nilofer Bhateja to deliver the vote of thanks.
Good evening, everyone. This was quite an evening. Although we are running beyond schedule, so I am going to keep the vote of thanks short and sweet. We hope our audience today were both enlightened and entertained by listening to the words of wisdom of our esteemed chief guest and of our guests of honor. First, I would like to thank Justice Suryakant for agreeing to be the chief guest and for releasing the book. Next, I would like to thank Justice Manmohan, Mr. R. Venkatramani, and Mr. Amitabh Kant for taking out time from their busy schedules to grace this occasion and for their esteemed presence and their words of wisdom. To the editors, Justice Sikri and Mr. Sumant Batra for trusting EBC to do justice to their book in a very limited period. Next, to Mr. Sumit Malik for attending the event and for his constant support and mentorship. To the EBC team, including Prachi, Bhumika, Anushka, Shubhra, Kriti, and Apurva, who were instrumental in putting together this event. To Ms. Mehdehi Gulati, Mr. Shiv Malang, and the rest of the ILA team for their constant support. Not to forget the staff at S Block Auditorium, especially Rajesh ji and Vipin ji, for helping us in hosting this event. And last but not the least, I would like to thank our wonderful audience for being with us on this occasion. With this, I would like to declare the end of this event. I would like to request our panelists and all our guests to proceed for high tea in the hall nearby. Thank you, everyone. Please proceed to the hall for high tea.